I'll now call forward 124116 in the matter of the marriage of John Holliday versus Tamara Holliday. Counsel. Ani, take your time to settle, but when you are ready, you may come to the lectern and begin.
May it please the court. Like I said, I'm Cecilia Mariani. I represent Tammy Holloway. Mr. Holliday must concede the following: that the decree was filed within days of the court's ruling in July of 2009, that the decree contained language pertaining to Mr. Holliday's Capers retirement account and the ruling by the court that the account would be divided 50-50. The date of the calculation, the date of the filing was the date of the division, and the percentage set over to Mrs. Holliday was fair, just, and equitable. And Capers, the retirement plan administrator, determined that the decree was adequate to serve as a quadro. We're asking the court to affirm Judge Etzel's ruling that the decree is the quadro and thus was timely filed. No other act was necessary. Delivery to Capers was a ministerial act of convenience along with the address and contact information from a client. The Court of Appeals reversed with no instruction, no remand to decide what to do next, and no finding that any other act would have been necessary or needed in order to cure its ruling. They created a procedural requirement that was unnecessary and applied dormancy to that procedure with ruinous results. At our hearing with the district court, and it wasn't just a hearing, it was a discussion. It was a discussion between, you can tell in the transcript, it was a discussion between all of us and the attorney for Capers, Kathleen Billings. Judge Etzel was involved. He asked questions. You could tell he was thinking about this issue, that it was a relatively novel issue, at least to him. And that he, being engaged in that discussion, the court can be confident that Judge Etzel's ruling was thoughtful and deliberate. Kathleen Billings testified. She gave an excellent presentation on what Capers goes through when it determines what a qualified domestic relations order is. And that we presented also in the court below, case upon case, about how the document doesn't have to say quadro. We've gotten into this mystery of what quadros are. And those of you justices that practiced in family law knew and still know that it is a quagmire that makes family law attorneys quibble with heartburn and indigestion over having to deal with a quadro. This document, the decree, was a domestic relations order that gave clear and unambiguous information on how to divide the retirement account, and was signed by a court and entered as a court order.
What does it mean then when the court told, I think, your client to prepare the quadro?
Well, at the time, he may not have realized if Capers needed something else, if there was something else that needed to be done to prepare the quadro. And it was frankly standard language in the decree.
When was it prepared?
28 days after the filing.
So it was prepared, but just not delivered to Capers.
No, not the quadro, the divorce decree.
Right.
Is what Capers accepted as a quadro. I'm talking about them one and the same.
But no quadro was actually prepared. It's just the decree.
Correct. No separate document saying quadro with the same information was prepared. And Capers didn't need it.
Because Capers is not covered by ERISA, which does reference qualified domestic relations.
But my argument would be that regardless of whether ERISA applies or not, that domestic relations order could have served as a quadro. Doesn't have to say.
But do we
quadro.
have to here? Well, let me tell you kind of how I've been thinking about this. It seems to me the questions are pretty simple. Number one, does the dormancy statute apply to your situation? And then secondly, does the time toll under the dormancy statute to your situation? Why do we have to even worry about whether this decree is the same thing as a quadro or anything like that? Why can't we? We know we don't have a federal law that says do a quadro for qualified plans, you know. So we've got this unique capers situation, it seems to me. And you put on evidence and the court accepted that if capers had received that divorce decree early, you know, right after the thing, they would have honored it, and they're still willing to honor it. The question is whether the dormancy statute makes this no longer an enforceable judgment. What am I missing by just looking at it that way?
The coincidence of being close to Mr. Holloway's retirement date is the only reason why capers needed that document at that time. The document was on file and it had been on file since the date of the divorce.
Not with capers.
Not with capers, but capers didn't need it. Capers didn't need it until the day he retired.
I understand.
And so that part of the dormancy doesn't apply. It just doesn't apply because there was nothing that could have been done on execution, if we call it execution of judgment, and I don't even like using that term, on separating Mr. Holloway's retirement account wouldn't have occurred until the day he retired. And it was simply coincidence that he had probably gone to his capers retirement seminar and figured out that capers needed a copy of the divorce decree.
Is the Court of Appeals decision in Larimore wrong or is it distinguishable?
Both. In my case,
Explain it to me.
Well, in
Why
my
is it
case-
wrong, and how do we distinguish it if it isn't wrong?
in my case, it would be distinguishable because one, we talk about, perhaps we can talk about on several levels. We can talk about the tolling, but also that it doesn't apply because the judgment, for lack of a better term, don't like using the term judgment, hadn't ripened. Mr. Holloway's account had not been awarded to him yet. He hadn't retired. Had other things happened prior to that retirement where somehow the policies and procedures of capers weren't followed in another sense that Mr. Holloway became no longer eligible for his retirement, there are narrow circumstances where that can occur, committing a crime, things like they're not following, there would be a deviation in capers policy where he wasn't retired, she wouldn't have gotten anything. Now, because the decree was on file, had he died prior to retirement, the amount would have been different, but it still would have been awarded to her. But we don't know what that amount was.
Let me back up. Let's start with your judgment that divided up the retirement account in the divorce proceeding. That judgment subject to the dormancy statute.
No,
Why not?
because it hadn't ripened yet. It was a 50%. It was not a number.
Well, is it subject to the dormancy statute? Is it a final judgment?
It's a final judgment.
And doesn't that make it subject to the dormancy statute? It may fall under subsection C, but don't jump ahead to that yet. I
Correct.
want to know whether, I
Yes.
just want to make sure we all agree that we're under the dormancy statute. We're simply trying to decide whether the dormancy period commenced.
We don't have to be, but yes.
Why not? I don't understand the answer.
Stop making Larimore apply to divisions of retirement accounts. Whether or not you find in different ways, whether my case applies or whether the dormancy
You're just
statute,
jumping ahead to the last question, which is that the right to collect doesn't occur until your case, Mr. Holliday retires, and that's when benefits are going to start flowing. I understand. That's your point, right?
yes,
Okay, but so now we're just in whether subsection C holds efforts to enforce the judgment until the time of collection, right?
right.
Why doesn't subsection C apply to your situation?
Subsection C does apply. I argued
Okay,
alternately.
but let's say it does apply, but why doesn't the judgment expire? Under
Because you can't do anything with this so-called judgment until he retires. She can't name beneficiaries. She can't separate the account. She can't open, the account isn't even
But she can't,
separated. It's separated in her name, but it has no funding.
she can create segregated accounts though, can she not?
No, she can't.
Isn't that what, well, correct me if I'm wrong. Isn't that what at least federal law contemplates when the qualified domestic relations order is being determined, that the plan administrator is supposed to segregate the amounts?
The plan administrator does, but Tammy can't.
But it wasn't it her responsibility to effectuate that by preparing the order, which would have triggered the plan administrator's obligation to segregate the accounts?
Correct, which they did prior to his retirement. She acknowledged at the hearing that it had already been received and at the time of the hearing, Mr. Holloway hadn't retired yet. And Ms. Billings acknowledged that the decree had been received and that the account was segregated. And that it operated as sort of a lien. I don't remember whether she used the word segregated at that point, but she said it operates as sort of a lien against his account. And I don't remember specifically what the procedure was at Capers, whether they segregated the account at that time or whether they waited until the day he retired and then segregated the account until that qualifying event occurred, because there were only two events that, or actually three events, but two events that would have affected her, and that is his death or his retirement, that would have triggered the division of the accounts. And she stated in her testimony that she would have received an amount commensurate with what the calculation would have been on the death benefit upon his death, which I got wrong at the Court of Appeals in the argument.
When did Mr. Holliday start collecting his benefits, if he has?
I don't remember exactly. It's not in the record, and I wasn't savvy enough to add it, make it a part of the record, but he has.
If the judgment would have gone to the plan administrator, this is a hypothetical, at Capers, and the Capers administrator said, ooh, this is a DRO, but it's not qualified. You need to make some changes to it. Is there a procedure for that?
Yes.
Okay. What is that statutory in nature?
I'm not sure whether it's statutory or regulatory. It's never happened to me, but I know that I have received a call from Capers asking for a copy of the decree.
And how can it be a final judgment if it can be amended?
Don't know. That's going to come up in the next case. I believe it is. If there are additions that need to be made. Now, it's not a Capers case, but in that case, additions needed to be made.
So is it additions or clarifications?
Clarifications need to be.
So is there a difference between like correcting a typographical error? You know, like, okay, you said you didn't put in how many months they were married or, you know, whatever it is. Is that a substantive change to the judgment, or is that a change based on?
Well, in times when that has happened before with other parts of divorce decrees or any other kind of journal entries, that would be up to the court to decide whether a nunc-pro-tunc would take care of it, to take care of clerical errors, whether you need to file a motion to clarify, or whether you need to file a motion to set aside and start all over again. That is, those types of hypotheticals have happened and happen in family law, especially when it comes to things like alimony and child support, trying to figure out
Did the district court judge have continuing jurisdiction over this domestic relations order?
I wish I would have argued that, because there could be the argument that he didn't. Well, or that he did up until the time Mr. Holloway retired. That everything was done that needed to be done. And unless there's some substantive change that could have been made or that needed to be made, no, his jurisdiction should have ended. And I wish I would have had.
His jurisdiction would have ended when?
when the decree was entered.
Right, but then that means it's a final judgment.
Well, no. It would be a final judgment that would be triggered by subsection C. That would mean it was uncollectible until he retired.
In
But
your
no
case,
changes could have been
in
made.
your case, Mr. Holliday filed a motion to render the judgment unenforceable because of the application of the dormancy statute, right?
Correct.
Did you submit I call it the divorce decree, but just the judgment that made the division of property? Did you submit that to Capers before he began collecting benefits?
Yes. And we received a letter that said, and I wish I would have added that letter to the record, that said this decree qualifies as type A quadro. And she testified to that at the hearing, that they had received the order and that it qualified as a quadro and that it would they would segregate. I don't think she used the term segregation, Justice. I'm not sure I don't think she used the term, but the transcript is there. That it would operate as a sort of lien on the account and that it would be ready when and if Mr. Holloway retired. Holiday, I'm sorry.
So is that why from your point of view, the judgment is not dormant
Correct.
because it was executed upon?
Yes,
And your argument is that the action that your client took to execute on the judgment was sending the order to Capers and getting that letter back.
so the action my client took to execute on the judgment was to file the decree.
That's
with-
what I meant, to send the decree to Capers.
Well, sending the decree, I'm particular about that because the timing on sending the decree becomes relevant. And that's one of their arguments, is that sending the decree was the act, and it's not. It's that sending
yeah.
the decree, it's a ministerial act.
But what is the act when did your client execute on the judgment?
When Judge Elder signed the decree.
I don't understand that
Well, it's
because the decree is the judgment
correct.
and then it has to be executed upon.
She didn't execute on the judgment.
So then why
Capers,
isn't it why doesn't it become dormant?
because the only entity that can finish that off is Capers. She can't. There's no other, and that's why
But
the
doesn't
ruling
she
doesn't
ha-
make sense.
Doesn't she have to do something?
No,
Well, what does it mean to execute on a judgment then?
that's why Larimore doesn't apply. There's no act. The Court of Appeals left no instruction and no act that she could have done to make that judgment happen.
Well, the district court told her to prepare the quadro. That was the act.
And we did it. We just didn't call it a quadro. We called it a decree. From Capers' standpoint,
But what was it that your client did? Just a second ago, you told me your client couldn't do anything and that it was the judge signing the order.
right, the judge signed the divorce decree.
But then you just told me you did do something, but you just didn't call it a quadro. What was
The
the
decree.
thing that you did?
The decree,
I'm still-
writing and
I'm
filing the
confused.
decree.
I thought you said the judge did that.
Well, he signed it. I wrote it. He signed it.
You gave Capers the divorce decree 12 years after it was entered.
Correct.
The point is whether the dormancy statute renders this judgment unenforceable because you didn't submit that to Capers within the time period of the statute.
If you apply the
5+7.
dormancy statute, if you say this judgment is subject to the dormancy statute, yes. That the timetable holds because the judgment had not ripened.
Is the decree divisible? And I guess my question is, whether it's hypothetical or maybe it's part of this decree, if your client was entitled to certain personal property and didn't receive it, certainly it would seem to me that if you didn't attempt to execute or levy upon that property within the statutory period, 5 years would go dormant and 2 more years it's gone. But I understand your argument that Capers is a different animal because even if you had submitted the decree to Capers within the statutory period, your client wouldn't have been able to draw upon any benefits until a qualifying event under the plan.
Correct.
So how do we divide it? Is a decree divisible under the dormancy statute?
Yes, I posit that, we posit that retirement accounts should not be subject to the dormancy statute. Larimore should not apply to the division of retirement. I don't even like the idea that anything under a divorce decree or separation of property is subject to the dormancy statute. When did ex-spouses become judgment creditors? I don't like that, but especially the dormancy statute should not apply to retirement accounts because of the changes that need to occur. Clarifications need to be made. In my case, it didn't. Capers had all it needed to do. But in other cases where the month calculation may not be correct, or the marital time may not be correct, or which account tier 1 or tier 2, remember railroad retirement on dividing railroad retirement accounts, doesn't distinguishing between tier 1 and tier 2. There's a term you hadn't heard in a while. How hard it was to get that language is exactly right.
I don't understand why this parade of horribles couldn't all this have been just avoided by either sending the decree or preparing a separate quadro and giving it to Capers right then and there? Wouldn't that?
Sure.
Well, so why is that so horrible?
It shouldn't have made a difference.
I understand that's your argument, but
Yes. It shouldn't have made a difference that she doesn't get the money because I didn't send the decree in time. Because the decree was on file, Capers didn't need it until he retired
Well,
and would have gotten it.
what about what I tried to ask earlier, probably didn't do it very articulately, which is that under section 414 of the federal code, it looks to me like the plan administrator does need it because they're supposed to create segregated accounts.
Capers isn't subject to 414.
Not through the Kansas statute's definition of a qualified domestic relation order doesn't.
Capers has its
Don
own
has-
definition of a qualified domestic relations order.
Let me ask you one other hypothetical. Assume with me that someone entitled, we have your facts, Mr. Holliday started receiving benefits and still had not sent the divorce decree to Capers 7 years after he started receiving benefit. Pharmacy statute then apply.
I don't know, but I would urge that it would depend on what Capers determined. Again, Capers has its own policies and procedures and ways of finding out whether or not the possibility of a division is to be made. Because they know when someone applies for Capers, when they start, they're married. And they can see when they're ready for retirement, if they fill out the forms and they're married to someone else. Capers has its own way, and Ms. Billings talked about that in her testimony, that Capers has its own administration in figuring out how those things worked. And again, I wish I would have, it's a long drive back from Holton when figuring out what questions I wish I would have asked, was to clarify those policies and procedures in the case of finding out when things happen and when Capers would consider it a problem of receiving that decree. Because by then she'd already received it. They determined it was a quadro. He hadn't retired yet and they were good to go. And it's not part of the record, but everyone has received their money. And the Court of Appeals, in reversing without giving anything further, has caused a difficult situation if that ruling is allowed to stand.
Can I just quickly follow up on my question about section 414 of the code?
And maybe I should have asked which one is 414? Because
Well, it's
404
the definitions of alternate payee and qualified domestic relations order. And I was under the impression that there wasn't necessarily any argument about the fact that section 414 does apply to this case through KSA 74-4923,
okay.
which says, as used in this subsection, and this is state law, the terms alternate payee and qualified domestic relations order shall have the meaning ascribed to them in section 414.
Okay. I thought because if 414 was part of ERISA, I just got it wrong. I apologize.
Okay.
So when you say, what was your question again?
Well, my question that partly this might just be my confusion in this area of the law. But I'll do my best to ask it clearly. It appears to me that as I read the definitions in section 414 of the federal code, it describes a qualified domestic relations order as a document, a legal document that creates and recognizes the existence of an alternative pay's right to receive a portion of the benefits under a plan.
And the decree did that.
But, okay, so that goes to my question of, isn't that what needs to happen to execute on the judgment?
Yes.
But it didn't happen until 12 years later.
No, it did at the time he signed, at the time Judge Elder signed that decree.
But the plan administrator didn't have that, did they?
Didn't need it until
But
the day.
well,
of the
that's
letter.
my whole question, is that it looks to me like under federal law, the plan administrator does need that so that they can begin, because that's what creates the existence of this alternative pays right.
Papers didn't need it.
Okay.
I should have made that a part of the record. Are there any other questions?
Thank you.
Thank you.
Miller?
Good morning. May it please the court. Again, I'm Shauna Miller with Joseph Hunter and Craft, representing John Holliday, the appellee in this matter. One thing I want to clarify, may or may not be factually important, but the term decree of divorce was thrown around a lot initially with argument. This was actually a trial to the court, and there was actually a memorandum decision that was issued by the court, which served as the decree. So there was no separate decree. That memorandum decision was signed and filed with the court on July 30th of 2009. So to the extent that's important, I wanted to clarify that issue. The crux of our argument is that absolutely dormancy does apply in this situation. The courts have held, and I think the statutes are clear, that the final judgment, that the judgment was final when this memorandum decision was signed by the court and filed with the clerk of the court on July 30th of 2009. Mr. Holliday did file his motion on March 31st of 2021, asking the court to extinguish this judgment, which was appropriate under KSA 60-2403. There's nothing in the record to indicate, nor would there be any evidence that at any time the ex-wife in this situation did any sort of renewal affidavit in this case. We would argue that based off Larimore Porterfield and his progeny, that there was nothing that would have stayed or prohibited her from essentially executing this judgment, which would have been in this case delivering it to Capers.
Right. So you mentioned 60-2403 with Justice Biles, subsection C.
Yes.
Okay, so if we agree with you that the dormancy statute applies,
Yes.
but then C is kind of an exception, where it tolls.
Yes.
And what it says is that the exception or the dormancy doesn't run during any period in which the enforcement of the judgment by legal process is stayed or prohibited. What does that mean?
So that would mean in this particular case, there was nothing that would prevent Ms. Holliday from submitting what was required in this case, the memorandum decision. Capers didn't require a quad reg
But she
because that
couldn't
was clear.
collect. If she sent it, if she mailed it the next day.
Absolutely.
She can't collect until your client applies for the benefits.
Yes, it's
So
not,
how-
So
how
it's
does
stayed
that
or
work?
prohibited.
it's not the collection, it's the execution of the judgment. It's sending that
No, it says
document to
enforcement.
Capers.
It says in 60-2403C, in which enforcement of the judgment
Yes,
by legal process is stayed or prohibited.
yes.
Is your argument that enforcement of the judgment is what I was describing as requiring the plan administrator to create segregated accounts?
Yes, yes.
But there are no segregated accounts with Capers. And
Capers.
so the problem I'm having is applying Larimore to a non-ERISA situation.
Right.
Because a quadro means something different in terms of its process, and not so much means something different, but the submission of its effect is different.
Right.
than with capers. And so it seems to me that we can distinguish Larimore, and now we're just trying to figure out whether subsection C means doing some act of, within the 7-year period.
Right.
That doesn't impact collection because
Right.
nobody can collect,
Right.
versus waiting until she can collect and then starting the dormancy period then. See that point?
Yes, so a couple of responses to that. One, in some cases, the application of ERISA may be important than this one. I think that in this particular fact scenario, I think whether or not ERISA applies or not is slightly less important. However, I can't tell you strongly enough how important it is that she took that step to deliver this document to Capers as a step to preserve her right to this retirement
Future
account.
right to
I'm
do,
sorry?
future ability to do something. That's
It's a
where I'm having trouble.
It is a future ability, but let me try to simplify this for you in, say for a collections circumstance. Let's say you have a judgment against somebody for $5,000. We know in collections that you need to do things like aids and executions. You need to attempt to collect on that. Well, let's say whoever you're trying to collect against doesn't have any money. You're required every so often to file this renewal affidavit to preserve that judgment until or unless you can collect. That's a very simplified way to kind of connect the dots with this.
But it's a determinable amount, isn't it?
And
Here
it's
the
determinable.
amount isn't even
It
determined.
is, but in this situation, it is also a determinable amount. That's part of the reason Capers didn't require the quadro is because the memorandum decision was very clear. She has a determinable amount between the date of marriage and the date of the memorandum decision or date of separation. I don't remember offhand which one it was. That's a determinable amount that Capers needs. And that's why it's so important that they receive this document timely.
It's a determinable portion of an unknown amount, correct?
Yes and no. It depends slightly. For example, as Ms. Mariani indicated, if my client died untimely, that could obviously affect what amount she would receive, but it's a determinable amount. The exact amount, yes, to be determined, but it's clear enough that again, Capers needed that document to know what that portion even was.
Let's take your hypothetical, and instead of you have a broke defendant that you're trying to collect from, your defendant is in bankruptcy. And you can't collect when they're in active bankruptcy.
Right.
So the enforcement of the judgment by legal process is prohibited or stayed, right?
Right, exactly.
So you're saying subsection C would apply there.
In a bankruptcy situation, yes.
But how is that different than what we have here?
Because again, there is nothing preventing her from delivering this document to Capers to put her on notice. Ms. Billings, who testified for Capers, essentially called it a lien. If you don't timely effectuate your lien, you could miss out. And that's exactly what happened here.
In the
Right.
Lar-
Go ahead.
Go ahead.
Well, I was just going to say, subsection C talks about enforcement of judgment.
Yes.
Black's law defines enforcement of judgment as a court's action to compel a person to comply with judgment, with the terms of a judgment, usually one made by the court. The prevailing party may ask the court to enforce its order, the party to collect on the damages awarded. It seems to me like if that is the definition of enforcement of judgment and the meaning of the plain language of that statute, that's a very different thing than just the ministerial act of sending the order to Capers.
Right.
It would be really something that doesn't happen until Capers would refuse to pay out.
I think I can understand what you're saying. And I guess, you know, the Court of Appeals has addressed this on a couple of issues. For example, the Porterfield case, they found specifically that was not the case, that just because the interest was kind of quasi future, although we knew the percentages that she would be entitled to, The fact that she wasn't due to receive this until sometime in the future, that did not apply. So I guess I would point the court to the Porterfield decision as they addressed that very specific issue. And they said it did not apply with a future interest in this retirement account. The future interest is simply a collection issue. She's entitled to it. It's just a collection issue. So I think that's
Let me
distinguishable.
point you to the Bank 4 Wichita case that's cited in Larimore.
Okay.
Because I really have a disconnect with what the Court of Appeals did.
Okay.
Be-
In Larimore in particular?
Larimore.
Okay, thank you.
well, then everything kind of flows from Larimore.
It
so,
does.
You know, it's like a disease. But anyway, the quote from Bank 4 Wichita says, the time within which a judgment must be, this is interpreting section C.
Okay.
The time within which a judgment must be enforced to prevent it from becoming dormant does not run during any time in which it is impossible to collect the judgment by legal process.
Okay.
So the Larimore court looks at that and says, oh, that doesn't apply because nothing in subsection C would prevent her from filing this required quadro for an ERISA qualified thing. And that doesn't make any sense to me.
Okay.
And so make it make sense.
Well-
Just because nothing prevents you from filing is not the same thing as what this court said subsection C means for purposes of commencing the dormancy period.
Okay. Can you clarify for me what the disconnect for you is on that issue?
Yeah, because Bank 4 Wichita talks about being able to collect the judgment.
Okay.
And this woman can't collect anything until your guy retires.
Right.
And so just the idea that I have a piece of paper and I can give it to Capers and they can put it in a file cabinet, I don't see how that nullifies the interpretation this court gave to subsection C, which is specifically about collection.
And I can appreciate that disconnect. It's still my contention that subsection C does not apply. She was not stayed or prohibited. She was required.
Why
to
does that
do-
matter when Bank 4 Wichita says it doesn't start to run until you can collect?
Right. And that's what I was trying to start to articulate. She has this judgment. She just can't sit and do nothing with it.
Is that
Um,
because collect is broader than getting a check, getting money in my bank
And
account?
that's kind of what I was starting to try to formulate is that, again, she can't just sit on her hands and do nothing with this judgment.
Ask it
Capers
this way.
doesn't know it exists until it's provided to Capers.
Once Capers gets that, does she have a real present property interest in that account?
I think that she has a real property interest in that account once a memorandum decision was issued by the district court. The steps she had to take to preserve that was to deliver that to Capers, and that didn't happen.
Is that a form of collecting on the judgment?
Delivering it to Capers, that's our position, yes. With any judgment, you've got to get it to the
But
next
your
step.
position is she could have collected on the judgment, even though actually receiving the money was something that would happen in the future.
And maybe it's a play on words, but I would phrase it more preserve her right to collect on it. Although, as the court indicated, she couldn't get a check right then unless Mr. Holliday died, left his job earlier or retired. If
I mean,
he
there are all
couldn't
kinds of future interests, which the law says you have a present property right interest in a future income stream.
Right, exactly.
I
But
mean,
what happens if she would have filed the day of the decree, right? And but the beneficiary of the Capers account doesn't retire for another 40 years. Under subsection A, and how you're explaining the statute, at least as I'm hearing it, that would suggest to me that's not even enough. Then every 5 years up until the date of retirement, she would have to file an affidavit to renew the judgment.
I think that's going a step too far. Again, delivering this judgment to Capers is the step to preserve her interest. I go back to the lien scenario where you file a lien and you don't have to renew a lien you don't do a renewal affidavit for a lien.
Why
That's
not? Because
essentially
doesn't
what-
subsection A say that the courts to release any lien on real property once it becomes dormant?
Say that again, I'm sorry.
Subsection A1, at least as I read it, contemplates that the district court should release a lis pendens once it becomes dormant.
Should release a judgment once it becomes
A
dormant?
lien on the property once it's dormant.
And I apologize, I guess I would have to pull up that statute in front of me. I'm visual, so.
But regardless of that, what language in the statute, what textual language says, responds to Justice Wall's question that a recipient, a beneficiary like Ms. Holliday,
Yes.
wouldn't have to repeatedly file this this alternate, file something with the district court that says, I'm still waiting
Right,
and this guy still hasn't retired.
right.
I don't see anything in the statute that says you don't have to do that if we interpret the statute your way.
Right. I think best practice would have been if a quadro was necessary, had been done, if this memorandum decision had been sent to Capers and Capers gave them either the blessing of, yes, we approve, this is clear enough, we don't need a separate quadro, or if a quadro had been filed, that would have been helpful. That didn't happen because this memorandum decision didn't get to Capers until 12 years later. So we have that unknown. We don't know what would have happened if it would have been timely delivered. I don't think that is what the dormancy statute contemplates in this particular situation. My assertion is that that memorandum decision was a final judgment, and that by her sending that to Capers and preserving future interest as far as putting Capers on notice that she had this future interest, it's our position that would have been sufficient. Nowhere in the domestic courts does it say that, you need to file once a quadro is done, that you need to, renew an affidavit for the quadro every so often. So I think that's not what the dormancy statute contemplates. What the dormancy statute contemplates, and why we're arguing that it's relevant in this particular case, is that she did not take that additional step of, once the memorandum decision was signed by the judge and filed with the court, she didn't take that next step to preserve that right.
I understand that now.
Okay.
Hypothetically.
Okay.
We interpret subsection C to say that dormancy clock doesn't start to run until she has the ability to receive a check.
Right.
Do you have any dormancy issue left in the case? Trying to figure out if we have to remand this back to the district court if we were to interpret subsection C the way I understand the facts is this thing got to Capers before your client started collecting benefits.
Right.
So we don't have any going on there.
I guess as you asked that question, it takes me back of our start date is this judgment interest. I know there was another case, and I think it was a Smith case, but I don't want to misquote myself. Yes, the Smith case that dealt with this military retirement where she was entitled to monthly payments through the decree versus this one time that the Capers set aside, and how the court distinguished that situation is each judgment was each month. I think that's completely distinguishable. With your particular scenario that you provided, that dated judgment is important along with the delivery to Capers to preserve that judgment. I think that even though she wasn't entitled per se to receive a check, I don't think that changes the analysis. I think it's that
I know
judgment.
but I'm basically
Okay.
trying to say, if we interpret section C the way I said, if nothing gets filed with Capers for 7 years
Right.
after your client started collecting, then section C kicks in and there would be dormancy at least for some window of time.
to me, from a common sense perspective, would cause an absolute nightmare. Imagine Capers not receiving notice that she's entitled to this money until the date that he collects, until 7 years after. What if he takes all of it out in one chunk? Then what's Capers supposed to do? That puts Capers in a heck of a bind, and it certainly puts Ms. Holliday in a heck of a bind. If Mr. Holliday's already withdrawn all the money and there's nothing left there. I think just from a common sense perspective, that would provide a logistical nightmare, not just in this case, but in other cases similar to it.
Isn't that why the plan administrator is supposed to basically create separate accounts? And this is just a question born out of ignorance.
Right.
Because I don't understand why Capers doesn't do that.
And unfortunately, I don't recall Ms. Billings addressing that issue specifically, but I know that once they receive the information, be it a quadro or be it a memorandum decision in this situation, they at least flag the account.
Right, but
And they know the date.
The statutes contemplate separate accounts, segregated accounts. And I've heard multiple times Capers doesn't do that, but that
Right.
seems to me to be what the statute contemplates.
And that would be logical. There's many retirements that do that, and I think that's probably better practice. But Capers, as Ms. Mariani indicates, has their own internal rules and regulations, and
It
that's
would
how they
seem to
do
me that
things.
if Kansas statutes.
Right.
Well, let me ask the question this way. Do you think the Kansas statutes contemplate separate accounts, segregated accounts, an actual segregation of amounts?
I guess it depends on how you would be defining segregation of accounts. I think certainly there is a flag on the.
Number, different name on the account.
I think
different
that would be,
accounting
I
of the-
think that would be best practice, and without having the statute in front of me, I'm not sure I could delve into that, but I think that at least, again, the administrator being put on notice that it's to
Well, that
be
fact seems
divided.
important to me because it goes beyond notice. It actually creates arguably a property interest in
Right.
the account, whereas
Right.
notice doesn't. Notice just says, look, when the retirement happens, it is like a lien, and a lien is not the same as a segregated account.
Right.
So from my perspective, that fact seems to be relevant.
Perhaps relevant. I don't know that it would completely redirect the finding that this court should make in this particular case. Again, had Capers been put on notice, they would have known that she was entitled to this amount at a minimum, depending on what their internal policies are, that I don't think we know based on this
The tolling
case.
provision of
They
C
would have flagged
doesn't
it.
talk about notice.
I'm
would
say
agree.
that one more time.
The tolling provision in subsection C of the dormancy statute does not talk about notice. You would agree with that, right?
I would agree with that related to subsection C, correct? Yes, I see I'm out of time. Are there any other questions? All right, I thank the court for your attention today. Thank
I
you.
have one, I
Yeah.
have one question if I
Yes.
could, Chief. So if the procedure had occurred the way you say it necessarily had to be
Yes.
done. And John went out and robbed a bank before he was able to collect on that Capers account.
Okay.
Such that it essentially goes away. He's not entitled to anything. What property would Tamara have?
And I guess that's presupposing that if John robbed a bank and was in prison, he wouldn't be able to access the Capers funds.
Well, I'm assuming at some point he's not entitled to any retirement. If
Okay.
an action occurs such that he doesn't get any retirement. What property would Tamara have? What recourse would she have?
It would depend a little bit on what Capers' internal policies are. For example, Ms. Mariani indicated that, for example, if Mr. Holliday died, that could change the amount of funds that Ms. Holliday would receive as part of the quadro.
My hypothetical, he's entitled to nothing.
That may not be a question I can answer because of whatever Capers' internal policies are based off death of the account, we'll call him the account holder, Mr. Holliday, the death versus the retirement, because those can change. What he's entitled to or his family would be entitled to upon his death versus his retirement, I believe would be different. Am I making sense so far?
I don't think you're following my hypothetical.
Well, I'm trying to get there. Your question is if Mr. Holliday does something horrible and is not entitled to receive any of his Capers benefits, what does Ms. Holliday receive?
What does she have?
assume-
No, what does she have?
what is her property interest? Not what does she collect under Justice Stiegel's analysis.
Right.
But what does she have? What is her property? If that
Um,
happens?
my opinion would be that if she would have timely delivered the memorandum understanding to Capers, that she would be entitled to at least that proportional, that, as the court, I think, indicated, undetermined portion, but that portion is set aside in the decree of divorce.
So 40% of nothing.
Assuming that Mr. Holliday's bad acts would entitle the entire, would make the entire count go away, which I'm not sure that would necessarily be the case, but yes, she would be entitled to a percentage of whatever was determined appropriate in that fact scenario. All right, any other questions from the court? All right, thank you so much for your time this morning.
Just very briefly. Ms. Miller talked about it, putting people in a heck of a bind if Mr. Holliday withdrew all of the money. You can't withdraw all the money from a Capers account. The most you can withdraw upon retirement is 50%, and then the rest you can take. You can draw up to 50% in a lump sum for those of you who have Capers. My understanding is you can withdraw 50% in a lump sum and the rest comes over time. And that has to do with everything in having to do with Capers and how they allow withdrawals. So there is no heck of a bind that anybody would be placed in had Capers not gotten the decree right before he retired. And I don't know, I wish I would have asked her what would have happened if she hadn't gotten the decree before Mr. Holliday retired. I didn't ask her that. Delivery, our position, and we argued it in our brief, was that delivery is not an execution act. And that's where the Court of Appeals went wrong by treating the quadro as an execution act, treating the delivery of the divorce or the memorandum in finding as an execution act, as opposed to simply a notice act, because not treating it that way dilutes the court's entry of the ruling. It dilutes anything the court would have done at the time. And we're not going to do that. And I hope not. And requiring, again, a renewal affidavit each time under her scenario is untenable as well. So I think we have adequately distinguished. If a distinguishment from Larimore is the way to go, then the court can do that. If applying Larimore and applying that subsection C tolls the statute, the running is the way to go, or treating Larimore like the disease that it is, Mr. Justice Biles, it needs to be overturned and not used in, not applied in retirement accounts for spouses. And I went back to a quick statement I made. When did spouses, especially in retirement accounts, when did they become judgment creditors? When did the woman who put him, ironed his shirts and sent him to work every day become a judgment creditor? And look at the cases. Now, it may be inappropriate and you can stop me if you want, but looking at the progeny of cases, Tamara Holliday, Donna Porterfield, Christina Strong, Janice Larimore, Pam Smith, Lisa Schaefer, even Mrs. Festini Steele, which I used in my brief below about arguing about her husband's life insurance policy several years after he had died, the decree applied that his life insurance, it was a 10th Circuit case that I used. Even Mrs. Festini Steele, that's right, Mrs. Even one of the cases we used, and this was a team effort, this wasn't me. I had a team with me. I have to thank them. Even the case in 1931 that we found that was about the mortgages. When the mortgage, she didn't bid the mortgage in the lien, she had a lien on one of the properties and there were two other mortgages, and she didn't bid the mortgage in the auction, and she thought the lien applied to the other two mortgages. She was a woman too. When are we going to stop and stop making our ex-wives judgment creditors. Thank you very much.
Thank you to both counsel for your arguments in this matter. The court will take this case under advisement.